Hi and welcome. My name is Matt Scudero. I'm with the Credit Research Foundation and extremely pleased to have the Lowenstein Sandler team with us again on a topic that you're going to find extremely interesting, but more so extremely actionable in your daily lives as a credit professional. We have Bruce, Eric, and Michael with us today. We're going to be talking about recent stimulus legislation, changes to the Bankruptcy Code. Again, this is changes to what impacts your daily lives as a credit professional. And again, I know you're going to find a lot of value in today's discussion. We are lucky enough again to have Lowenstein Sandler with us. They are a friend of the foundation, constant contributor of education across all fronts on CRF to us. And Bruce and Mike and Eric, we're extremely grateful for all that you do for the discipline as well as for CRF. I know you got a great presentation prepared for us today. Why don't we pass the baton, and it's all yours. I look forward to the content.
Thank you, Matt. This is Bruce Nathan. And hello, everybody. Hope everyone is safe and getting out more. You will notice maybe a big news item is if you look at the screen, I am in my office. I'm in the New York office at least once, maybe even twice a week. You can see a nice office as opposed to a bare wall if I was at home, which makes it a little more spicy. And this program is spicy. We're discussing the impact of some recent legislation on the Bankruptcy Code and changes to the Bankruptcy Code. And if we go to the first slide, we're going to first discuss, and Eric Chaffetz is going to take the laboring of this later on in the program, the Consolidated Appropriations Act of 2021. Only Congress can name something as something that is in 2021, even though it was passed on December 21, 2020, and signed by the president in 2020. But I guess since we were around Christmas time, everyone decided we're going to call it a 2021 statute. And this was, everybody knew about this because this was a $2.3 trillion spending bill. This was the spending, probably the most important piece of legislation that ended 2020. And one of the very few bipartisan pieces of legislation. You had $900 billion in COVID-related relief and $1.4 trillion of omnibus spending for all of the appropriations that were not otherwise passed on their own by Congress for the fiscal year 2021. Well, the Bankruptcy Code was a part of the Consolidated Appropriations Act. There were amendments that were very, very relevant to trade creditors. And the most important amendment, again, Eric will cover this later, deals with preferences and a new preference exception, or maybe preference defense, something called covered payment of supplier arrearages, actually an effort to help creditors that accommodated their debtors by extending out payments. Where that may not otherwise be subject to a preference defense I'll be talking about, this legislative change actually does attempt to extend protection from preferences for these covered payments. Eric will talk more about how this is going to work and how the legislation was not drafted that well, which is going to lead to a lot of litigation, yippee for bankruptcy lawyers. But again, it is attempted increased protection for trade creditors. There were also changes to the post-petition financing PPP loan for small business debtors. Then Eric will talk about some extensions of deadlines for debtors on commercial leases and limits on utilities in their ability to terminate services. Before we go to the next slide, though, I'm also going to be discussing very, very quickly another change that Eric will also be talking about. That is the Small Business Reorganization Act of 2019. That became effective February 19, 2020, right before the pandemic. This it was an effort to encourage more small businesses to utilize Chapter 11. It's a different type of Chapter 11. It's faster, it's cheaper, it's a quicker timeline. It actually encourages small businesses to utilize Chapter 11 rather than other non-bankruptcy devices. And I'll be talking about that in the context of some preference changes in just a few minutes. Let's go to the next slide. So I'm going to be focusing on, we're all going to be focusing on the impact of both the Consolidated Appropriations Act of 2021 and the SBRA on preferences. So give you a very quick tutorial of the elements of a preference claim, which is contained in Section 547B of the Bankruptcy Code. It puts the burden on a trustee or debtor in possession to recover certain payments that were made prior to the filing, so long as the trustee can satisfy its prima facie burden of proof for preferences as follows. It's got to be a transfer of an interest of the debtor in property. Well, any payment from the debtor's bank account, that's a transfer. There are other types of transfers, like granting of security interest, entry of judgments. But most of the transfers that are alleged as preferences are payments. They were made to or for the benefit of a creditor, trade creditor like you all, on account of the antecedent debt owed by the debtor before the transfer. Any invoice with terms amounts to antecedent debt if the invoice is paid in accordance with terms or late or even early. Now, cash in advance payments, where cash is paid, the creditor receives the payment before providing the goods and services, that can't be a preference because there's no antecedent debt that was ever paid. Let's go to the next slide, please. Additional burdens, proof for the trustee to prove a preference. The payment or the transfer was made while the debtor was insolvent. That's a balance sheet insolvency of liabilities more than assets. And that is presumed, insolvency is presumed within the 90-day preference period. And there are two preference periods. There's a 90-day preference period for non-insider creditors like you all as trade creditors. And there's an expanded one-year preference period for transfers made to insider creditors. Those are people who are officers, directors, controlling persons, if you're dealing with companies, members of the board of directors, etc. And again, insolvency is presumed under the statute during the 90-day preference period, which makes it easier for the trustee to prove. And finally, the last element is that the transfer enables the creditor to receive more than the creditor would receive if the case were a Chapter 7 case, the transfer had not been made, and the creditor received payment to the extent provided by other provisions of bankruptcy code. But in plain English, less than 100 cents for creditors, that requirement is satisfied. Let's go to the next slide. Where the Small Business Reorganization Act comes in is it amended Section 547B of the Bankruptcy Code to add a due diligence requirement before commencing a preference action. Let's just take a step back. When the ABI Commission studying Chapter 11 held its hearings around the country, it held a hearing before trade creditors, and trade creditors had an opportunity to testify. And their biggest complaint about the preference statute was that the concern that trustees were just going through check registers and picking up all checks that were allegedly written within 90 days and allegedly paid to a creditor. And the problem there is sometimes the checks were never sent, sometimes the checks bounced, and just using the check register was an abuse. And there was testimony that trustees should have some responsibility to do some diligence with respect to being able to prove all of the elements of the preference claim I just discussed. And one of the changes that the commission proposed was actually enacted as part of the Small Business Reorganization Act. And that was a due diligence requirement. Essentially, the trustee had to, before the trustee could file a complaint, he or she had to exercise reasonable due diligence, taking into account a party's known or reasonably known affirmative defenses under Section 547C of the Bankruptcy Code. Now, what does that mean? It's totally unclear. In fact, it's unclear because preference defendants still have the burden of proving their defenses. And so that to the extent that a creditor has an ordinary course of business defense or even a new value defense, they have the burden of proof. But this due diligence requirement does require that the trustee do some analysis, some diligence of the defenses available to a creditor. Now, the ordinary course of business defense, as I'll discuss in a second, is very subjective, and you can take the same set of facts and a trustee or a creditor could win. The new value defense, well, that's a little clearer. Where this comes in is to the extent that the trustee was just looking at a check register and there was a bounce check. The question is did the trustee conduct reasonable diligence in terms in satisfying its burden of proof? And even there, it's unclear because the books and records of the debtor are usually in shambles. And to the extent that the trustee doesn't have very much to work with, they may very well only have a check register to deal with. And if they see payments within 90 days, they have every right to at least presume initially that those payments are subject to preference risk. Now, where this gets interesting is if there's a demand letter that's sent out and the creditor ignores the demand letter, again, that may be fair game for the trustee to say, you had every opportunity to respond to the demand letter. And if you didn't respond, then I exercised my diligence. I sent a demand. Nobody responded. I relied on whatever books and records I had. Here we go. Where it gets interesting is if the creditor responds to the demand and the trustee ignores that, and they're ignoring some very, very apparent defenses, it's very interesting as to what a court would do. And what's so interesting here is that there have been a few courts that have actually addressed this issue already. At least one court really did not put much of a burden on the trustee in satisfying this requirement. Another court was a little tougher. But again, it's going to be very, very interesting to see how this additional due diligence requirement actually unfolds, and most importantly, whether it's treated as an element of the preference claim that has to be pursued, or as part of the defense that a creditor can assert. Let's go to the next slide. Okay, so we talked about, we'll talk about the defenses to a preference claim. And there are two defenses in particular that creditors need to deal with. One of them is the ordinary course of business defense. The other is the new value defense. I'm not going to talk about the new value defense because it's not implicated in any of the changes to the bankruptcy code that were brought about by either the CAA or the SBRA. The ordinary course of business defense, though, is relevant. And let's just talk about that for a second. It's a very difficult defense to prove because it's very subjective. There are three elements to it. You only have to prove two of the three. In order to prove an ordinary course defense, you got to prove that the payment was of a debt incurred in the ordinary course of business of the debtor and creditor. Well, that's pretty easy to prove if you're extending normal trade terms, or really any trade terms. That's debt that was incurred in the ordinary course of business of the parties. Very, very easy to satisfy as a non-insider trade creditor. Then the creditor has to prove either that the payment was made in the ordinary course of business or financial affairs of the debtor and the creditor, which is a subjective test, or that the payment or transfer was made according to ordinary business terms and it was made within the range of terms that characterizes a relevant industry. Creditor's industry, the debtor's industry, people like the creditor selling to people like the debtor. And the creditor gets the benefit of choosing the most beneficial, which is the easiest one to prove. If they can prove that the payment satisfied the objective test, they don't have to satisfy the subjective test. And as long as the debt was incurred in the ordinary course of business, the creditor wins. Now, what happens in this situation, and this is kind of going to get us into the next section of the program, and that is what happens if a creditor modified its payment terms for a customer due to the pandemic. And again, we heard this a lot back in the day of March of 2020. The creditor modified its payment terms. The debtor was asking for more time. Businesses had shut down. Creditor was offering 30-day terms. The debtor asked that it be extended. They could pay in 60 days, 90 days, 120 days. And so we had that extension that was granted. Well, the problem that the creditor has is that if they allowed for a longer payment, they lose the benefit of the subjective element of the ordinary course of business defense to the extent that the debtor was never paying that slow in its history. And if that sort of slow payment was not characteristic of the industry, there's a loss of the ordinary course defense where the creditor was trying to do a good deed by working with its customer to allow its customer more time to get to make payments. That is what the CAA change is intended to bring about. And by the way, I made an error because the CAA is going to be discussed not by Eric Chaffetz, but by Mike Papandreou. And I I have been hearing a beep on my phone the last few minutes, and that might have been Mike saying that. So you see right here live, Nathan making an error. I erred in the speaking order in the speakers. No big deal. So I'm going to turn this over to Mike, who does a good thing on the phone. It takes me a while to figure things out, to actually talk about the covered payment exception to preference liability that was enacted as part of the CAA. And Mike, my apology for messing up. But I did restore it by getting you back in order. So
no problem, Bruce, and thank you to our listeners, one for listening to this presentation, but two, giving me Bruce on a recording saying that he made a mistake there, so I can throw that in his face anytime I want down the road.
Anytime.
But anyway, so Bruce was basically just talking to you guys about how a creditor who tried to do a good deed for a customer in distress as the pandemic was starting to hit, or as the pandemic kept rolling along, ultimately could run into a situation, insofar as the ordinary course of business defense goes, that if a preference action is asserted against them, they'll learn that no good deed goes unpunished, because by the very definition of changing your credit terms in order to assist that customer, the vendor may have removed its ability or eliminated its ability to assert the ordinary course of business defense, or the subjective ordinary course of business defense, to the extent that they modified those payment terms. So with that said, and as Bruce led into, Congress tried to remedy that situation, or at least seemingly tried to remedy that situation, by enacting a new subsection to the preference statute of the Bankruptcy Code, Section 547, and that subsection is Section 547J. And ultimately, it provides it sets forth a new exception to preference liability, not a defense, an exception to preference liability for covered payments of supplier arrearages. And I'm going to read off to you, just to start this off, almost verbatim what the statute describes as a covered payment of supplier arrearages. It's not exactly a quote, but it's close. And a covered payment of supplier arrearages is a payment made in connection with an agreement or arrangement made or entered into on and after March 13th, 2020, which is the onset of the COVID pandemic, or at least the related economic shutdowns, between a debtor and a supplier of goods or services to delay or postpone payment of amounts due under an executory contract. So if that was a mouthful of a bunch of words that don't necessarily make sense right out of the gate, and leaves you with a bunch of questions, don't worry, you're not alone. It leaves me with a bunch of questions too, and I'm sure Bruce and Eric would agree, as much as us lawyers like to think that we always know everything. But as a quick aside before we get into those questions, since we have it highlighted here, just wanted to note, because it'll guide some of the discussion, that an executory contract, as many of you may know, there's no definition for it under the Bankruptcy Code, but generally speaking, courts rely on what's called the countryman definition, named after the source that created it. And it's an executory contract is one under which both parties to the contract have so underperformed their obligations or unperformed their obligations, such that the failure of either party to continue performance would constitute a breach by that party that would excuse the other from performing. So for example, if there's an obligation to supply goods and pay for those goods that remain ongoing, that would be an executory contract. Another common example would be potentially a lease, where there's obligations on both the lessee and lessor. Moving on to the next slide. So, breaking down the covered payment exception just a little bit here. The statute provides that the payment cannot exceed the amount due under the executory contract before March 13th, 2020. Sounds simple on its face, as I'll get to later. It may not be so simple, or at least it's very problematic in how it's drafted. Another important piece to note about a covered payment of supplier arrearages is that a covered payment cannot include fees, penalties, and interest in an amount greater than that scheduled to be paid under the contract, or which the debtor would have owed had the debtor made all payments on time and in full before March 13th, 2020. we'll dissect that a little bit further in a little bit. Also want to note that while the focus of this presentation is on covered payment of supplier arrearages, given our anticipated audience, Congress did also enact an exception for landlords too. That's substantially similar, called the covered payment of rental arrearages exception. The statutory provisions relating to that one are very similar to the extent they can be. They're identical almost to the covered payment of supplier arrearages exception. So while it may not necessarily be relevant to all of you, we just wanted to note that here so you don't think that we forgot about its existence. And the covered payment exceptions, both of them, they sunset on December 27, 2022, but they'll continue to apply to bankruptcy cases filed before December 27th, 2022. So really, the impact of it lasts a little longer than that actual sunset date. So, as I alluded to before, while the concept of the exception really sounds simple enough, and we think that the intent of the exception is pretty simple or easy to deduce, that it was intended to, protect a supplier that may have extended terms in response to the COVID pandemic and the related shutdowns. Unfortunately, the exception might raise more questions than answers that it provides. So the first of these questions is, who has the burden of proof under this exception? Is it the trustee or the plaintiff, whether it's the trustee or the actual debtor in possession, or is it the creditor? Who has to prove up this covered payment exception? And so the exception was drafted in such a way that one would think that it is the plaintiff that has to prove it as part of its prima facie case. And that's because of the distinction between section 547B and 547C. So earlier, Bruce was running through the elements of a preference claim. Those elements are found in section 547B of the Bankruptcy Code. And those are the elements that the plaintiff has to prove in order to establish its initial case of a preference claim. Section 547C, on the other hand, is the section of the Bankruptcy Code that sets forth defenses to a preference claim. For example, the ordinary course of business defense that Bruce was discussing. And so, therefore, one would think that depending on which one of those the new subsection 547J relates to, that'll give guidance as to whose burden it is to actually prove it. The plaintiff would have to prove the elements of the claim. The defendant creditor would have to prove its defenses. And 547J actually is drafted such that it amends 547B, which would lead us to think that, therefore, when the plaintiff files its complaint, it has to somehow show that the payments that the plaintiff is asserting are preference payments are not covered payments of supplier arrearages. But unfortunately, it's unclear to us that that'll actually be how things play out, because frankly, similar to the due diligence requirement that Bruce was discussing, these plaintiffs can file these complaints, and until somebody files a response or an answer or motion to dismiss or what have you, what they assert in the complaint, it is what it is, right? And also, it's the creditor will be holding the facts for the most part as far as what a covered payment may be. So as a practical matter, it'll probably be the creditor who has to be on their toes to actually assert that the payments are covered and therefore accepted from preference liability. Another question that arises out of the statute is, what is an arrangement to defer or postpone payments? So the statute covers payments, an arrangement or an agreement to defer payments, which implies that an arrangement is somehow different than an agreement. So does that mean that a creditor's unilateral decision to defer payment would be sufficient if just one day the creditor said, oh, okay, the COVID pandemic hit, I'm going to be nice to my customer, I'm going to just defer terms as a matter of course? Is that an arrangement? Who knows? Does the creditor have to at least announce the deferral? Does the creditor have to then maybe let the customer know that they deferred terms? Would that then make it an arrangement? It's unclear. Or ultimately, does an arrangement need to be in writing to ultimately be an arrangement? Again, until courts speak to this, we won't necessarily know the answer. But frankly, our advice is that if you want to best arm yourself or put yourself in a situation that you have the covered payment arrow in your quiver to be able to shoot it at a preference claim, then at least insofar as this defense or this exception goes, you would want to you'd probably want to document and execute forbearance agreements so that it's clear you have an arrangement or agreement to defer or postpone payments. And here are some of the two bigger questions that arise out of this. So first off, can the creditor defer payments while requiring the payment of late charges, interest, and attorney's fees? So as you recall, the statutory language said that a covered payment cannot include late charges, interest, or attorney fees in excess of what the debtor would have owed had the debtor been current on its obligations, which is somewhat puzzling language because unless the executory contract, that the payments were deferred under somehow included fees that just had to be paid out of in the ordinary course, it's really hard to imagine what fees, late charges, or interest would be payable if the customer was current, right? So we would imagine that this is a wholesale ban on them insofar as being able to apply the covered payment exception to them. But then the bigger question that then arises out of that is, if the agreement or arrangement to defer payments included some form of late charges, interest, or attorney's fees, does that take the entire agreement or arrangement to defer payments out of the covered payment exception so that the payment itself on basically what I'll call the principal amount owed isn't accepted from preference liability, or is it solely with respect to the late charges, interest, and attorney's fees themselves that can't be covered under the exception? We don't know the answer to that, but it's certainly something to consider. And finally, and this is certainly the most troubling piece of it if you want this exception to have much meaning at all, and that is, what is the meaning of the requirement that a covered payment not exceed the amount due under the executory contract before March 13th, 2020? So one way of looking at this is perhaps this piece is saying that a covered payment can exceed amounts that would be due in the ordinary course of the contract as the contract existed on March 13th, 2020. So there could perhaps be charges that would have been incurred after March 13th, 2020, but so long as they kind of existed under what the contract currently was, then maybe they could constitute covered payments. That's probably too broad of an interpretation because it would largely moot what I'll call the ban on late charges, interest, and attorney's fees if that's all it was intended to mean. A little more limiting of an interpretation, or actually very much more limiting interpretation, would be that a covered payment cannot exceed the amount of whatever claim the creditor would have had on or before March 13th, 2020. So let's say, if the creditor was owed, say, pick a number, $50,000 on March 13, 2020. At no point can the creditor use the covered payment exception to cover an amount of preference exposure of more than $50,000, which perhaps that's a fair interpretation of it. But an even more limiting interpretation would be that a covered payment can't exceed the actual amount and can only be applied against the actual amount due under the executory contract before March 13, 2020. Which would of course be extremely limiting if there's no carry forward of that balance. It's just only applicable to the amounts due and owing on or before March 13, 2020. And it's troubling that could be the interpretation and ultimately the meaning of this statute, because that would basically mean that if a creditor, the pandemic lasted, we're still pretty much in it. Luckily, we see the light at the end of the tunnel, but the pandemic lasted for over a year and is still going. And an agreement or arrangement to defer payments, as a result of the pandemic, which is presumably what this statute was meant to address, could have occurred in, say, April 2020, May 2020, and so forth, right? And so the fact that there's this limitation here that basically the trigger date is the eve of the economic shutdowns, the very first day of the pandemic, it really makes it such that it's not clear how useful this exception really will end up being. That said, we don't say that to scare you off from keeping it in mind and being prepared to assert it, because as any of you who've dealt with these types of litigation or any litigation will know, when you get hit with a demand or a complaint gets filed, you want to assert as many defenses as you can to give yourself negotiating leverage. So we certainly are not saying, hey, forget about this defense, or this exception, but don't necessarily be too surprised if as things play out, it may not ultimately be as much use as we would have liked before the courts. But we'll see as it potentially gets litigated before the courts how these questions get answered. So with that, unless Bruce or Eric have any comments on that exception, I'm going to pass it on.
I do. And I think
I thought you might.
I think this last point is the most problematic in this new exception. I think it's almost like the draft is just frozen time where creditors are as of March 13, 2020. Probably the most logical interpretation would be if the creditor was owed $500,000 as of March 13, 2020, that is the limit of the covered payment exception. To the extent of any accommodations that were made on or after March 13, 2020 to extend indebtedness. The problem with that is that if it prevents, to the extent there were transactions that say started March 14th, one could argue this section doesn't even apply to that if it only applies to indebtedness that was due as of March 13th, unless you look at that as a cap number that can apply to anything through the life of the statute. That is what's going to make this a very, very difficult exception to prove, and the burden of proof is going to be critical. But Mike, I think as you said, what creditors need to do is come up with a strategy as to how they can fit within this section, how they can argue that the payments were made pursuant to an executory contract, which is a challenge if you're dealing just with purchase orders, and how to argue for as large a covered payment exception as possible to cover transactions that occurred after March 13, 2020. And I think the best practice of documenting your forbearance agreement as an agreement, as opposed to doing something more loosey-goosey, is going to be very critical in that regard, because you can use that documentation to try to satisfy some of these requirements in the agreement, the forbearance agreement that you're entering into. We can go to the next slide, which I believe gets us to Eric Chaffetz. Eric?
Yes, thank you very much, Bruce, and thank you, Mike. So I'm going to begin my discussion with a discussion of the Small Business Reorganization Act, or colloquially referred to as the SBRA, which Bruce alluded to previously. That act became effective on February 19th, 2020, and the intent was to grant Chapter 11 protections to debtors with a small amount of debt on a faster and cheaper timeline. The ways that was supposed to be accomplished was that there weren't going to be creditors committees. There was going to be no absolute priority rule, meaning equity can keep their equity under certain circumstances, even though unsecured creditors aren't paid 100 cents on the dollar. There would be a trustee appointed to administer and assist with the process. A disclosure statement, which usually accompanies a plan in larger Chapter 11 cases, would not have to be filed. And only the debtor and no other third party would have the ability or the standing to file a plan. So there wouldn't be any exclusivity issues that sometimes get fought about in larger cases. As I indicated before, the SBRA only permitted businesses with an aggregate debt of about $2.725 million to file Chapter 11 as a quote unquote small business debtor. Mike, if you don't mind, go to the next slide. The CARES Act, which was passed on March 27th, 2020, and originally was set to expire or sunset on March 27th, 2021, unless it was extended by Congress. It is usually referred to, it's the act that Bruce and Mike had alluded to with respect to a lot of the preference exceptions. Significantly for the purposes of my portion of the discussion, that act increased the maximum aggregate debt limit to qualify as a small business, provided for under the SBRA to $7.5 million. But not less than 50% of that debt, however, could arise from, it needed to arise from the commercial or business activities of the debtor. What does it mean to arise from the commercial or business activities of the debtor? Your guess is as good as mine. I don't think that issue has been litigated yet. The COVID-19 Bankruptcy Relief Extension Act was introduced by Senators Durbin and Grassley. It was passed on March 27th, 2021, not too long ago. That extended the sunset date for certain bankruptcy-related provisions of the CARES Act by 1 year through March 27th, 2022, such as the increased maximum debt limit of $7.5 million, which we just discussed, which would allow larger small businesses to qualify as small business debtors. Mike, next slide, please. The CAA amends Section 364 of the Bankruptcy Code to provide that bankruptcy courts may authorize small business debtors to obtain loans under the Paycheck Protection Program. Those loans significantly could be forgiven if certain conditions are satisfied. That includes that the proceeds of the loans are used to cover certain categories of allowable expenses, including payroll, costs, mortgage, interest, rent, utilities, etc. Mike, next slide, please. One big issue with the original CARES Act is that it was silent about whether companies in bankruptcy could obtain PPP loans. The CAA reverses certain court decisions that upheld the Small Business Association's original determination that debtors in bankruptcy were not eligible for loans under the CARES Act. There's a handful of cases that cut both ways before the CAA was passed. In the 11th Circuit decision in USF Federal Credit Union versus Gateway Radiology Consultants, that court held that debtors could not obtain PPP loans, excuse me. Other courts, however, have held alternatively that debtors had a right to obtain the loans. However, as I alluded to before, the CAA provides that PPP loans will only be available if the SBA administrator sends a letter to the director of the Executive Office of the United States Trustee permitting PPP loans in bankruptcy. In other words, even though there was supposed to be some clarity under the CAA, it's still unclear whether PPP loans will ultimately be available to debtors.
Hey, Eric?
Yes, Bruce.
Yeah, before you leave this, there's something that very recently happened that shows you the absolute lunacy of this provision. The SBA is allowing debtors to access these PPP loans, and I believe they've exhausted already, so I'm not even sure, where this goes going forward, to Chapter 11 debtors that are seeking exit financing to get out of their small business Chapter 11 case. So if you're a debtor in bankruptcy and you're looking to exit, the SBA may permit a PPP loan to be used as a source of exit financing. But that doesn't help the debtor that's in bankruptcy, that's in desperate need of capital. That's only when the debtor is trying to get out of Dodge. It really doesn't solve the problem. There is, and again, I'm not sure if the PPP loan program has exhausted or, whether, it will be extended. So this whole issue of PPP loans in bankruptcy has really been troubling and nothing short of confusing.
No, thanks, Bruce. And to your question, my understanding is that for the most part, the PPP loan program has been exhausted, but there may be a little bit of money left over from some of the other programs that Congress passed. So we'll see what happens.
I'll make a bet that there may be some way to extend this because that appears to be a bipartisan issue. There are very few of them left. We'll see where it goes. But on bankruptcy, I think the bipartisanship is that bankruptcy is complete confusion when it comes to the applicability of the PPP to debtors seeking capital in their Chapter 11 case.
Yep, definitely. Mike, if you don't mind, go to the next slide. Thank you. The next topic we wanted to turn to was a discussion of Section 365D of the Bankruptcy Code. That section of the code deals with commercial leases. The fallback provision is that under Section 365D5, a debtor must substantially satisfy all obligations arising from or after the 60th day after the bankruptcy filing under an unexpired real property lease until such lease is assumed or rejected. We'll talk about the time frame for when a debtor has to assume or reject a lease in a second, unless the court orders otherwise based on the equities of the case, or in other words, for cause. Oftentimes, prior to the pandemic, the standard to demonstrate cause in order to forestall the debtor's ability not to make those payments during the first 60 days of bankruptcy was extremely, extremely high. However, since the onset of the pandemic, courts have generally allowed debtors to stop paying rent, certain obligations, subject to certain adequate protection requirements within the first 60-day period. However, the issue had become, and I'm not admittedly sure if it's really still an issue now based on the fact that there seems to be some additional normalcy coming back to the country. But the issue had been whether that 60-day period could be extended based on the specific facts and circumstances caused by the COVID pandemic. There is, as you can see from the slide, a split in the case law as to whether that was appropriate. In Modell's, which is the first case to test the proposition, and in Pier 1, which occurred shortly thereafter, the court allowed there to be an extension of time. However, in the Southern District of Texas, in CEC Entertainment, which is the Chuck E. Cheese case, the court held that the time may not be extended. It's not 100% clear exactly why the courts came to their decisions, but just to throw out a few things for the group. The Modell's case and the Pier 1 case, they both transpired or were filed at the onset of the COVID pandemic. And they were filed and dealt with stores mainly in the Northeast and on the East Coast, in New Jersey for Modell's, and Pier 1 for the Eastern District of Virginia. The CEC Entertainment case, granted, they have locations across the country, but that was filed in Texas. And the views of the Texas courts may have been different than the views of the New Jersey courts and the Eastern District of Virginia courts, especially since in CEC or Chuck E. Cheese, that occurred much later on during the pandemic. Mike, if you don't mind going to the next slide. So I alluded to before that there's a deadline under the Bankruptcy Code for debtors in a Chapter 11 case to decide to assume or reject a residential real property or a non-residential real property lease. Under the CAA, a small business debtor, so this is small business debtors, this isn't every Chapter 11 debtor, this is a debtor now based on the extension of the sunset provision with less than $7.5 million in debt. Their time to perform under an unexpired non-residential lease could be extended based on a showing of financial hardship caused by COVID-19. The debtor may extend its performance for up to 60 days after the bankruptcy filing. In addition, the court could grant an additional 60-day extension for, and I'm doing this intentionally, small business debtors, if the debtor approves a continuing COVID-19 hardship. It's a very factual inquiry as to whether there's a continuing COVID-19 hardship, and courts will decide that issue on a case-by-case basis. This act also extends the time for a debtor. So this is not a small business debtor. This is a debtor filing a case under the normal Chapter 11 provisions to assume or reject non-residential or non-residential real property leases from 120 days to 210 days, excuse me, as a matter of course, subject to an additional 90-day extension without the landlord's consent. This is significant because back in 2005, when the BAPSIPA statute was passed, landlords spent a lot of political capital convincing the Congress to reduce these timeframes. This provision, like some of the other provisions Mike and myself alluded to previously, sunsets on December 27th, 2022, but continues to apply to bankruptcy cases filed before December 27th, 2022. Next slide, please. Thanks, Mike. The last topic that I wanted to touch upon was the treatment of utilities under the CAA. Section 366 of the Bankruptcy Code generally provides that a utility provider cannot cut off services to a debtor so long as the debtor provides quote unquote adequate assurance of payment, i.e. a security deposit. In certain jurisdictions, that's a month of utility costs, a month and a half, 2 months, really depends on the case, within 20 days after the bankruptcy filing. The CAA amends Section 366 to prohibit a utility from discontinuing utility services to, and this is significant, to an individual debtor, regardless of whether the debtor provides adequate assurance of payment. However, the debtor must pay the utility provider for services rendered in the 21 days following the bankruptcy and continue to make all other post-petition utility payments. This provision, again, sunsets on December 27th, 2022, but continues to apply to bankruptcy cases filed before December 27th, 2022.
And I think that concludes our program. If anyone has any questions, our contact information is attached to the presentation that you're getting. Eric, Mike, and I would love to entertain your questions. You have a lifetime warranty, and the answers are all off the clock. So with that, we wanted to tell you again, thank you for listening. We hope all of you remain safe. We look forward to seeing you at a future CRF function. The virtual forum, I hear, is in August, and we are really excited about the actual in-person forum that's happening in October. Look forward to seeing all of you there and celebrating, hopefully, the end of the pandemic and the return to a new normalcy. Thank you all, and have a great day.
Bruce and Eric and Mike, I want to thank you, right? Bruce, I think you opened up that this was going to be a spicy, I think you used the word spicy presentation. And I appreciate that because it is a spicy topic, right? There are a lot of changes and a lot of impactful changes to the credit professional. And they need to be aware of that. And as always, the team has done an excellent job of sharing that detail with us. We can't thank you enough, not only for today's presentation, but for being a friend of the foundation and the constant contributor that you are to all things credit and all things CRF. And this particular presentation also ties very nicely to the educational session that you did for CRF on preference actions, and would advise folks to take a look at that as well. That is just an extremely well done piece. As Bruce said, I hope everybody stays healthy, stays safe. We look forward to seeing you again real soon. And again, as a final thank you to not only Bruce and Mike and Eric, a thank you to the Lowenstein team for all that they do. Look forward to seeing you guys real soon. Take care, folks.
Thank you.
Thank you.
Yeah.
Are we off?